First test of Trump's power to fire officials reaches Supreme Court. In the first case to reach the Supreme Court arising from the blitz of actions taken in the early weeks of the new administration, lawyers for President Trump asked the justices on Sunday to let him fire a government lawyer who leads a watchdog agency. The administration's emergency application asked the court to vacate a federal trial judge's order temporarily reinstating Hampton Dellinger, the head of the Office of Special Counsel. Mr. Dellinger leads an independent agency charged with safeguarding government whistleblowers and enforcing certain ethics laws. The position is unrelated to special counsels appointed by the Justice Department. This court should not allow lower courts to seize executive power by dictating to the president how long he must continue employing an agency head against his will, the administration's filing said. The court is expected to act in the coming days. The filing amounts to a challenge to a foundational precedent that said Congress can limit the president's power to fire leaders of independent agencies, a critical issue as Mr. Trump seeks to reshape the federal government through summary terminations. The statute that created the job now filled by Mr. Dellinger, who was confirmed by the Senate in 2024, provides for a 5-year term and says the special counsel may be removed by the president only for inefficiency, neglect of duty or malfeasance in office. But a one-sentence email to Mr. Dellinger on February 7 gave no reasons for terminating him, effective immediately. He sued, and Judge Amy Berman Jackson of the Federal District Court in Washington entered a temporary restraining order allowing Mr. Dellinger to keep his job for 2 weeks while she considered whether to enter a preliminary injunction. Temporary restraining orders are generally not appealable. The statute, Judge Jackson wrote, expresses Congress's clear intent to ensure the independence of the special counsel and insulate his work from being buffeted by the winds of political change, adding that the government's only response to this inarguable reading of the text is that the statute is unconstitutional. Judge Jackson was appointed by President Barack Obama. A divided 3-judge panel of the U.S. Court of Appeals for the D.C. Circuit on Saturday rejected the government's emergency motion for a stay of Judge Jackson's ruling. The unsigned majority opinion, joined by Judges Michelle Childs and Florence Pan, both Biden appointees, said the government's motion was premature. The question here is not whether the president is entitled to prompt review of his important constitutional arguments, the opinion said. Of course he is. The issue before us is whether his mere claim of extraordinary harm justifies this court's immediate review, which would essentially remove the legal issues from the district court's ambit before its proceedings have concluded. In dissent, Judge Gregory Katsas, a Trump appointee, said he would have blocked Judge Berman's ruling, thus allowing Mr. Dellinger to be removed from office. Citing recent Supreme Court decisions, he wrote that, Congress cannot constitutionally restrict the president's power to remove the special counsel. You want more updates? Please like and subscribe now.